Hi, this is for Chapter 3, Residential Leasing for the residential real estate transaction. Just to recap, in Chapter 1, we talked about the residential housing. In Chapter 2, we talked about the residential condominium. Now, this is more towards the leasing side of it. Um, to note that more than 30% of the all private Ontario dwellings are occupied by renters, and the total rental occupied dwellings in this province exceed 1.3 million. So it's a big number, and it probably means we're also signing about 1.3 residential leases as well. So in this chapter, we are going to discuss and provide examples of four major types of tenancy, including fixed term tenancy, periodic tenancy, tenancy at will, and tenancy at sufferance. Differentiate between residential and commercial tenancies. Detail the essential elements of a legally enforceable lease. Discuss key provisions of agreement of lease residential. Outline the role of landlord and tenant board with particular emphasis on mediation and education process. Discuss selected provisions of the Residential Tenancy Act as they impact commencing a residential tenancy. Discuss specific provisions in the Residential Tenancy Act concerning termination by the landlord and by the tenant. And residential, also the role of the Residential Tenancy Act has in addressing special provisions concerning conversion of residential premises to condominiums. Again, whenever a residential premise is converted to condominium, the rights of the tenants are always upheld. Let's go. Let's start off with the various types of tenancy. So there are basically four types of tenancy. The first is a fixed term. Second is a periodic tenancy. The third is tenancy at will, and the fourth is a tenancy at sufferance. So a fixed term tenancy provides that the tenants with exclusive possession for a specific term, which is normally agreed to in the written contract. In a fixed term lease, both the commencement and the expiry dates must be determined before the lease takes effect. In a commercial fixed term tenancy, the tenancy ends on the expiry date and no notice is required. However, it is usual for tenure to continue for a periodic basis. In residential tenancies, if the tenant remains in possession of the property following the expiry date, the tenancy is deemed to continue on a month-to-month basis pursuant to the provisional tenancy legislation. Periodic tenancy. A periodic tenancy is for a fixed period but indefinite length that can be made certain by notice of termination. In other words, a periodic tenancy automatically renews itself unless a notice is given to the contrary. In residential tenancies, a periodic tenancy can be either in writing or oral, and may simply state the tenancy is on a month-to-month basis. If the residential tenancy remains, if a residential tenant remains in the property following the expiration of fixed term tenancy, the tenancy relationship normally converts into a periodic tenancy automatically. Tenancy at will. Tenancy at will can arise when, after expiration of a lease or when no lease exists, the tenant remains in possession with the consent of the landlord or the person entitled to possession. Real estate entrants should be aware that a tenancy agreement can occur by contract or by implication from the act of the parties. An implied tenancy at will may arise when the tenants occupy the premises without rent. An express tenancy at will may arise when the real estate transaction does not close on the scheduled date and the possession is granted in anticipation of future closing. Tenancy at sufferance. This type of tenancy may occur if the person has possession without the consent of the owner and without paying rent. It arises by the implication of law in situations where tenancy has been terminated but the tenant does not vacate. Tenancy at sufferance might typically arise if the tenant did not vacate after a prior notice to quit or did not vacate after the fixed term tenancy expired. Residential versus commercial tenancies. Residential tenancies have more statutory rights than their commercial counterparts. Clearly, the distinction between the two is vital, and the important item here is the principal use. essentially means what the premises is basically used for. And this criteria is an important aspect in distinguishing residential from a commercial tenancies. Statutory exemptions like accommodation for traveling or vacation by vacationing public, seasonal or temporary accommodation, farm employee occupancy, conditional employment, non-profit housing, cooperatives, penal or correction facility employee with accommodation in the same building for non-residential and accommodation contingent upon continuing employment, occupant sharing kitchen or bathroom with the owner or family or his family, living accommodation for rehabilitative or therapeutic services. Those are a couple of statutory exemptions. Lease. A lease is defined as a contract between the landlord and and the and the tenant or leasee for occupation, use of a landlord property by tenant for a specified time or for a specified consideration. Purpose of the lease is to establish written record of agreement between the parties for a tenancy arrangement within the defined period. Essential element of a lease includes the legal name, uh, and also like if the person is legally competent. Uh, the person signing must be legally competent. This is particularly important in the management of retirement and nursing home, and signature of spouses or guarantors are obtained where applicable. Reasonably identified description, legal description of the lease premises should ideally be entered. However, as long as the description allows for space or specific property to be readily identifiable, this requirement is considered fulfilled. So essentially, just to recap, the essential element are the legal name, the full legal name, correctly spelled, of the individual or a corporation that a party to the lease must appear, should be legally competent, and this is especially important in case of retirement and nursing homes, and the signature of spouses or guarantors are obtained, should be readily identifiable description, consideration that is exchange for of something of value, in a lease amount of rent, method of payment, and to whom the payment is addressed are detailed. Legal purpose, the lease must include a description of the legal purpose for which the premise is to be used, start and end date, and what is expected. Lease versus agreement to lease. An agreement to lease is technically referred to as agreement to lease without settled form of lease. An agreement to lease generally sets out fundamentals and material aspect of the lease between the parties, but contemplates the execution of the formal detailed lease. An agreement to lease covers substantive issues and is best described as a consensus leading to the final agreement. So essentially, a lease and the agreement of lease are two different things, but it is possible for the lease to be used, um, or rather, it's possible for the agreement of lease to be used, and could be the company documentation for the lease in entirety itself. And the agreement of lease is technically called as the agreement to lease without settled form of lease. Drafting an agreement to lease. Registering and drafting an agreement to lease must ensure that all essential elements of the lease are included, namely parties, description of the premise to be leased, the commencement of the lease, the term of the lease, and the amount of the rent. All other material in the lease, other than the specific exceptions, reservations, covenants, or special conditions, are implied by law. So, agreement to lease read residential form 400 sets out the lease fundamentals and substantive terms, and the rental application sets out applicable information that can be used to a prospective residential tenant, including details of the owners and other occupant. Last two places of the rental application for sets out the applicable information, acceptable information that can be used by that can be asked to a prospective residential tenant, including details about the renter and other occupants. Last two places of residence, present employment, financial obligation, and personal references. The form complies with the Privacy Act and also informs the applicant that a consumer report containing credit and personal information may be referred to in connection with the rental. A fully completed agreement to lease, residential and rental application as application to lease. There are various clauses that needs to be looked into. Credit check. In some instances, a landlord may not use a formal rental application but still require a credit check to be performed in accordance with the Consumer Reporting Act. As the remainder, as a reminder regarding statutory requirements, if the landlord refuses to grant a lease due to the information contained in the consumer report, he or she must give notice that the refusal was due to the information received. Landlord is also obligated to inform the prospective client of the nature and source of information received, and if the tenant so requests, in writing within 60 days of the refusal notice. No lease to be signed. In some situations, the landlord and tenant may decide that the agreement to lease is sufficient and a formal lease document is not necessary. In this case, the tenant and agreement might insert a clause saying that the tenant and agreement agree that an accepted agreement to lease shall form a complete lease and no other lease will be signed between the parties. If this clause is used, ensure that the clause to execution of the lease in the statement to lease in the agreement to lease is ruled out and is initialed by the parties. Chattel maintenance and related issues. As with all real estate negotiation, registrant face unique circumstances that must be addressed in the agreement, such as alteration, improvements, appliances included, cleaning of carpets and at commencement by landlord and by tenants at termination, maintenance of grounds and swimming pool and so forth. First right of refusal. A first right of refusal is a contractual right that can involve any assert. In this example, the tenant is obtaining the first right of refusal from the lease premises. The first right of refusal provides that before before the seller can enter into a transaction with a third party, he or she must first allow the tenant a specified period to submit an offer on the same terms and conditions. Landlord and the tenant board. Landlord and tenant board is a quasi is a is a is a is a quasi judicial. Essentially, it operates like a court of law, but not in all respects. Members of the board are appointed by the provincial government. The board operates in the terms of rules of practice interpretation guidelines and makes such rules and guidelines as well as approved forms available to the public. The landlord and tenant board is involved in various activities that include determining matters pursuant to the application made by the parties, making findings, making and issuing orders, mediating situations, and educating. Mediation versus education. Mediation is generally described as a process of bringing about some form of agreement or reconciliation between the opposing parties. This process has proven particularly effective in resolving a wide variety of disputes that might otherwise extend into lengthy hearing or legal action. The board often mediates issues that arise as a consequence of application made by either landlords or tenants. Mediation is not mandatory. The board will not become involved in the mediation process concerning tenancy disputes unless the application is received. Further, even with the application, the decision may be made not to mediate if the resolution is by this means appears impractical. Conversely, education is the process of deciding and settling by law issues arising between the landlord and tenants pursuant to the Residential Tenancy Act. Residential Tenancy Act. Residential Tenancy Act is a complex piece of legislation spanning numerous provisions and new provisions that not only impact residential premises but also care homes and land lease properties. Starting a residential tenancy, various statutory provisions relate directly or directly to the tenant application and selected process. Selected topics include the rental history and credit references. Regulation 298 under the Ontario Human Right Code sets out permissible landlord practices including tenant credit references and rental history information. The landlord may request credit references and rental history information and authorization to conduct a credit check or a guarantee for the rent in addition to the rent deposit in order to access assess and subsequently select and refuse a tenant. A landlord may request income information only if the items detailed above are also requested. If such details are obtained, income information may be used in conjunction with that information to assess and subsequently select or refuse a tenant. If such details are requested but not obtained, income information can be considered on its own merit when selecting and refusing a prospective prospective tenant. Pet provisions. Any provisions in the tenancy agreement that forbids animals is an violation of the Act, but there are exceptions do apply, like for example provisions in the Ontario Human Rights Code and pet restrictions in the condominium. Rent deposit: the landlord can request a rent deposit, but it should not be more than the lesser of the amount of rent for one rental period or 1 month. Any reference to a security deposit is automatically deemed to be the rent deposit for the purpose of the Act, and the maximum rent deposit is 1 month rent. Registrants should be aware of certain important requirements regarding the rent deposit. If the lawful rent increases, the landlord may require tenant to pay the appropriate additional amount concerning the rent deposit. The landlord may require to pay the tenant interest annually on rent deposits. Such interest is calculated on a percentage change from year to year in the Consumer Price Index of Ontario for prices of goods and services as recorded as reported monthly by the Statistics Canada, averaging over 12 months period that concludes at the end of May of the previous calendar year. Rent deposit is applied to the last rent period prior to the termination of the tenancy. The tenant is not required to provide a landlord with a post-dated check or agree to automatic withdrawal debit payment from an account. The landlord must provide a receipt to the rent and rent deposit upon request by the tenant. Rent provision: lawful rent. Residential Tenancy Act provides that no charge of rent or the increase of rent is allowed greater than the lawful rent permitted. Rent increase requires a 90-day notice. Cannot increase rent above the guidelines. Rent guidelines published by Ministry of Municipal Affairs and Housing by August 31 based on the CPI until the end of May. Increase above the guidelines is possible if the new additional services are provided or there is a capital expenditure or more security services are provided, and even that can be at most 3% above the guidelines for the maximum of 3 years. So it also requires that the landlord make application for the capital expenditure and increase. There's landlord cannot restrict reasonable access by the election candidates, cannot change entry locks system to the residential unit without providing the replacement keys. Landlord right of entry is again under two separate areas. One which requires within 24-hour notice, like repair and law potential mortgagee or insurer or potential purchaser, or a good state of or to maintain a good state of repair, and also ensure the health maintenance and safety standards are maintained. And without notice can only be under an emergency, or if there is regular cleaning that is under the agreement, in which case then he can enter from 8 a.m. to 8 p.m. Assignment and subletting. Landlords can consent or refuse an assignment, or but if he doesn't respond in 7 days, tenant can give 30 days notice of termination. Landlord cannot arbitrarily withhold consent to sublet. Again, in the case of sublet, um, the original tenant is liable. Termination. Termination can be by the landlord or by the tenant. Termination before the end of the period. Reasons could be like non-payment of rent. Termination for cause like illegal act, misrepresentation of information, damage, interference, etc. or repeat of selected clauses, or and there is the notion of a reduced notice period. At the end of the term, there can be a demolition which requires 180 days of notice. Possession required 60 days of notice. Sale of the property also requires 60 days of notice, assuming it contains less than 3 residential units, and other specific provisions like rent not on the due date, qualification, tenant, employer, and condo. But tenant, uh, daily or weekly tenancy like 28 days, monthly 60 days, fixed term 60 days, special tenancy situations in case of condominium conversion. Residential Tenancy Act provides tenant security of tenure in the event residential complex is converted into a condo. I think with this we are at the end of chapter 3, residential leasing. Thanks for your time.